Good afternoon. This is Steve Wilkes of counsel with the Wagner Law Group in our San Francisco office. Welcome to today's webinar. Very glad that you're able to join us. Today we're going to be talking about advisory agreements and then a little more focus on one of the key areas that are discussed within an advisory agreement, compensation. But we're going to take a slightly different slant, because typically in the past we've done webinars before and put out a lot of written material on agreements and related issues with a very heavy ERISA focus. And today we're going to be going through some of these basic components of the agreement as a little bit of a refresher back to the core Investment Advisors Act considerations. And I say that because, you know, as a law firm, we are involved with many, many hundreds of advisory agreements every year. And oftentimes, the ERISA, and rightfully so, has a very important part in that dialogue. But we all need to remember in this world of dual regulation and dual governance that it's not just the DOL. We have the SEC and the Investment Advisors Act of 1940 to think about as well. And sometimes those issues don't get the full discussion that they should have. So I thought that today our firm would go over and highlight some of the key considerations, looking through a little more of an Advisors Act lens, just to refresh everyone and remind everyone of the dual importance of that regulatory regime as well. So we're going to talk about the advisory agreement and focus also on advisor compensation. And I'm also going to then diverge a little bit to performance compensation under both the Advisors Act and ERISA, because we see a lot of that in the private fund world, where fund managers, hedge fund managers are having, you know, fulcrum fees or some other sort of incentive compensation. And there are a few things to think about there from both an ERISA point of view and the Advisors Act point of view. And that's our agenda for today. So let me begin by talking about advisory contracts, mostly from the Advisors Act perspective for purposes of today. You know, this relationship, this relationship between the advisor and the client is really contained and defined in the contract itself. It doesn't necessarily have to be in writing. It's not required per se, but obviously I think 99.999% of these arrangements are in writing. And advisors might use different types of agreements or contracts that help them establish this relationship, and that's fine. For example, we see a real difference at the retail level in terms of kind of the agreements we see for private wealth management and advisory agreements that are up at a more institutional level involving, you know, collective investment funds or mutual funds or institutional funds. You know, in these agreements, they have to be consistent, of course, with the Form ADV that you're filing, and that's one of the big things I would call out to you. We've seen many, many instances where the advisory contract might be a little out of sync. It might understate or overstate something in terms of the Form ADV, and you end up with a conflict. So it's very careful that we always check for consistency and that the terms are uniform among those two, or that we have a savings clause. We might say that we might have language in a Form ADV that says, these are our general terms and conditions on payment, subject to specific requirements that are contained in the applicable advisory agreement, which might vary from client to client. So those are the ways that we kind of work around those. So again, we have to line up with the ADV, and you know, advisory contracts can cover a lot of areas. We're going to talk about fees and services, some, you know, contract issues, administrative issues, liability, dispute resolution. You generally want to see a good set of reps and warranties from each side. And like any good contract, there should be provisions for not only how the relationship begins, but how it ends, i.e. termination, how it might be assigned or amended. And the Advisors Act doesn't require written agreements for many of these provisions, though I would also point out that under applicable state law in certain states, there might be a requirement for writing, which is not necessarily set forth in the Advisors Act. So that's something to keep in mind. Now, generally speaking, we see advisory contracts in writing in the ERISA world because, hey, it's a good fiduciary practice, it's the way to go, and if you're a 338 discretionary investment manager, there has to be some acknowledgments that you're a fiduciary, among other things. So that's something to think about there. Fees are a big part of these agreements. You're going to see a fee schedule, when the fees are payable, percentage of assets, hourly rate, flat fee. You'll want to see some good discussion on how the market value of the account will be determined. Sometimes it's at the beginning of a quarter, sometimes it's at the end of a quarter. It might be based on an average value during the quarter. There are proration provisions that should be put in, some different ways to handle that. And it'll also provide oftentimes that the advisory fee can be deducted from the client's account, by the custodian, and these are subject, of course, to various, these have implications under the custody rule of the Advisors Act, but that's something that needs to be set forth. And I would say for ERISA purposes, you want to know that this aligns with the terms of the plan. It's nice to see a plan provision that allows for plan assets to be used for advisory fees, as well as having it set forth in the advisory agreement. You also might be talking about how brokerage commissions might be paid, or other transfer fees and other kinds of charges that come through the various institutions. So when you think about all these fees that are potentially set forth in the advisory agreement, people always need to be aware. The Advisors Act says that compensation cannot be based on a share of capital gains or capital appreciation, and I'll talk a little bit more about performance fees later. And then there's a special provision with regard to mutual funds that says an advisory contract has to accurately describe, I think the word is precisely, has to precisely describe all compensation paid to the advisor. So fees are going to be a big part of these contracts. We're going to have a section on the scope of services. On the ERISA side, we typically break them out as fiduciary and non-fiduciary. But here, but kind of looking at it again through the Advisors Act side, there's so many different things an advisor might do for a client. You so obviously want to describe that scope of services. If you're managing assets, you want to be very clear whether it's non-discretionary or discretionary. And you also want to be clear whether you are directed to a specific broker, i.e. direct brokerage, or whether the client delegates or allows the advisor to choose one. And if that happens, if the advisor is allowed to choose a broker, then you want to get into some discussion around how it meets its duty of best execution, whether or not the advisor can use an affiliated broker. You want to talk about aggregation of orders with other clients when executing trades. And if the agreement allows the client to direct brokerage, then you might want to get a representation or acknowledgement from the client that says, we picked the broker. We recognize that we might not necessarily be getting best execution, but we picked the broker. Because the whole idea of the best execution, aggregating trades, bunching trades, can all be big pieces of the advisory relationship. I think another thing that we like to see typically is how proxy voting is handled. And that's simply a designation as to whether it's going to the advisor or staying in the, in some other party or in the shareholder name. Conflicts of interest is going to be a big portion here, and hopefully this should map very carefully to form, the ADV Part 2A. It should map over very carefully to how those conflicts have been described in terms of affiliated products, affiliated services, affiliated parties that may be earning compensation on this relationship. From an administrative perspective, there are lots of things to be handled. You might, designating the custodian of the account. You want to know that it's whether or not that custodian is appointed by the client or the advisor, and whether, the custodian will take directions from the advisor in terms of investing or payment of fees. Usually it's good to set forth a protocol for what kind of meetings will be held and what kind of reports will be provided by the advisor to the client. And sometimes it might read a little bit, we've had some agreements where the agreement itself looks almost a little bit like an IPS, because you'll get into some detail on the client's investment objectives, if there's any limitations. That could be a separate attachment as an IPS. It can be built into the agreement itself. And sometimes we also see language around confidentiality and whether or not the advisor is allowed to rely on information provided to it by reputable financial service third parties or not. The liability piece is a big piece of these contracts. You're typically going to, the SEC, by the way, as many of you know, the SEC really doesn't like indemnification clauses and hedging clauses. They don't like anyone to try to limit, liability or kind of hedge off on those risks. But there's an appropriate place in these agreements, and they should be there. And it's very good business and appropriate from a legal risk management point of view for these agreements to define the nature and extent of each party's liability. And these are generally going to be enforceable, unless there's, some sort of, fraud or negligence behind it, or perhaps there's an inappropriate waiver of rights to action, which the anti-fraud provisions of the Advisors Act would not allow you to take. And we also need to remember that the Advisors Act itself would void any term of an advisory agreement that binds a person to waive compliance to any provision of the Advisors Act. So a provision that tries to hold an advisor to a standard of care or a level of duty lower than what the Advisors Act itself requires, which is a very heavy fiduciary level of activity, just like ERISA, that would be invalid. I think another area that we sometimes like to look at a little more closely and put some thought into is dispute resolution and how controversies are handled. It's good to say that the contract will be governed according to the law of a certain state, provided it's not inconsistent with the federal law, i.e. the Advisors Act, and that you might want to have something about arbitration. Again, the SEC gets a little they take a very close look at arbitration. In the old days, the SEC took the position that this might be illegal, requiring parties to an advisory agreement to be bound by arbitration, because it somehow confused clients that they otherwise couldn't, seek other rights of action under the federal securities laws. And there's a series of court cases on that. But I think most arbitration provisions nowadays are supported, and they tend to be reasonable, in the context of the Advisors Act itself. But I would just note for you that there's a little bit of an overhang sometimes on how arbitration works or how it should work. You're going to see some standard reps and warranties in these agreements, the status of the parties, whether or not it's registered, whether or not proper disclosures have been made, in terms of Form ADV Part 2A and 2B and other requisite disclosures. One of the things that we see a lot that needs a little more attention, I think, is how these disclosures are made. I think it's good to be adding some language about electronic disclosure. The SEC, has had a series of announcements on the use of electronics in terms of making, filings and making regulatory disclosures. But the world changes so quickly. When those regulations were written, I don't think people really realized that you could push a button on your handheld phone, which fits into the lower half of your wallet, and send and receive documents and check boxes. I mean, technology change is occurring so rapidly. But I think it's good to have some thought-out provisions in there as to whether you're going to allow for electronic communication, and that's two ways. I think the advisor has to ask itself, do I want to be responsible and deemed to have received an email as compared to a FedEx or UPS overnight delivery of some major notification from a client? What if my email address changes? How do I know I have the right email? How do I know someone's checking the email every day? So I think you need to think about it both ways, both inbound and outbound communication, whether or not electronic communication is appropriate. I think it can work and should work in most cases, but it needs to be a little bit of a protocol behind it, maybe a little more thought on it. And the other things that we'll see in these representations and acknowledgments will be, an approval of, either, a consent to cross-trading or principal trading if your advisory firm is engaged in principal trading, and the fact that, advice might differ from client to client, things like that. I think that the advisory contract in terms of termination and assignment and amendment should be fairly specific. But we typically see termination on written notice or maybe on 5 days or 10 days. I think the arguments in favor of a longer period of time allow for a fiduciary-like transfer of responsibility from the disengaging party to its replacement, if it's the advisor that's terminating. And you have to be wary of what kind of penalties are provided. Translated, that means there should be no penalties for termination. Maybe there's a way to get an administrative costs, or fees in advance obviously can come back, but the language needs to be very careful in termination as to the timing, who's responsible as to the point of time when the notice is given. Are there any overhanging responsibilities that go beyond that? Administrative fee, pro rata refund of advance fees. And in terms of amending, most agreements have a very typical for provision to say this agreement may be modified by writing, signed by both parties. We're seeing people go more and more to negative election for amending, and there's a parallel on the ERISA side under the old Aetna advisory opinion. I can't remember what year that was. I think it was 96. But basically, a lot of advisors take the view that maybe the percentage of asset fee is going to be increased from 30 bips to 35 bips, hypothetically, or the service might be curtailed, or the timing of meetings, or the frequency of meetings might change. An advisor has a certain number of clients. It's hard to go around and repaper all these agreements. Some advisors do that can be a challenge. It can be daunting. So we see a process whereby negative election is used, which means a writing is sent to the client, and that writing might say, in 60 days or in 30 days. We typically don't like to see anything shorter than 30 days. 60 is even better. But, in X number of days, our fees will increase from 30 bips to 35 bips, or we will be meeting on a semi-annual basis rather than a quarterly basis, things like that. If we do not hear back from you in writing, you'll be deemed to have consented. And that way they solve is this an administrative solution, if you will, to providing effective notice without having to go around and repaper with every client. Now, some clients like to be seen by their advisors, and some advisors really look forward to the opportunity to get in front of their clients as frequently as possible. So for some people, the chance to go around and have a visit with a client and repaper all these agreements is not a problem at all. It's an opportunity, and that's great as well. So I would say, on these, the other things I would point out here on the that we've seen on these agreements from an Advisory Act point of view, I mentioned before the need for consistency with the Form ADV. I think whether or not you are listing the specific IAR that's handling the account is something to think about. A lot of agreements will say the XYZ firm or registered investment advisor and Mr. Smith or Bank 25 are hereby enter into this agreement. But a lot of times, this is such a relationship-driven business, a lot of times people will add the IAR for specific reasons, and that's great. It raises some questions as to, potential liabilities, as if the IAR is an employee rather than an independent contractor. It also raises a question on termination. If the IAR moves to another firm, does the IAR have the right to take that client with him or her? Or is the client relationship really owned by the advisory firm? So I think there's some advantages and disadvantages to listing the IAR as a named party to the agreement, and if so, defining the scope of that designation, what it really means. That's something to think about. We see some issues there every now and then. Indemnification is always a negotiated point. It's not required per se. We have a lot of discussion around indemnification that we should probably take a little better look at. And again, I mentioned before, electronic consent and negative election. So those are some of the things that we see, forgetting about the pure ERISA side. Those are some of the things that areas of the agreements that we come across under the Advisors Act that there's some SEC guidance and authority on and should be given, due consideration when preparing your agreements with the client. Now, compensation is one of the big pieces of an agreement, and I want to talk a little bit about advisor compensation as well. Again, just to kind of talk about it in terms of a little more from the Advisors Act side. Obviously, you know, these arrangements can vary. You know, it can be a fixed fee. You know, people have all sorts of sliding scales, flat fees, hourly fees, and generally the most common one we see, of course, is a percentage of assets, and sometimes it's on a tiered scale. And I think a lot of times people are a little surprised when they realize that there is some flexibility. There are a couple of different ways that you can go about setting these fees and setting the scale and determining, you know, how you're going to be paid and what the amounts are going to be. So I think just automatically assuming that you're limited or locked into a straight percentage of assets is not necessarily something that has to be adhered to. There are a lot of state laws that parallel the Advisors Act on fees. I mean, the bottom line is there are really no prescribed limits on what an advisor can charge. There are restrictions on performance fees, and I'll talk about that. But there's otherwise there are really no restrictions other than that they're, you know, they're fair and reasonable and properly disclosed. So I think in this era of competition among advisors to gather assets and deliver service for value and transparency around these fees, I think we're starting to see and entertain some interesting discussions about different fee structures and how it might be handled. Obviously, compensation has to be disclosed, and you can see that on the ADV in terms of advisory fees. That's a fiduciary responsibility under the old capital gains case. And you know, the SEC has issued some guidance about fees that serve as a benchmark for us. We know that fees have to be reasonable, as they have to be under ERISA. And you know, the SEC staff always says that fees are reasonable, in relation to the services provided. So it's not a question of being at the cheapest fee or the highest fee. It's a question of the fee that makes the most sense in terms of the value proposition, in terms of what you're getting for it. And I think the SEC would look at, in terms of fee reasonableness, they're looking at, you know, what's charged in the market by your competitors, whether you know, the same services could be obtained directly without any assistance or cost at all. Otherwise, why are you charging a client for this? They can get it themselves directly. And, you know, whether the advisor has a belief that its services somehow benefit the client, you know, that they're going to end up with gains in excess of the fees, and a series of no action letters on that. The SEC has talked a little bit about, well, they've given a lot of advice about fees in connection with affiliated mutual funds. And here, they're talking about the disclosure that has to be given when an advisor manages money, you know, invested in funds managed by that advisor, in a proprietary fund. So in effect, what's happening is clients are paying two fees, a direct advisory fee, and then indirectly they're paying it again because the fee is paid by the mutual fund of the same advisor. This is okay as long as we have very clear disclosure. There used to be a time when there was an offset required, but you know, as long as you have the right disclosure and you can show that you're furnishing distinct services for each fee, you know, that will hold. I think in terms of percentage guidelines, the SEC has said that an advisor might be deemed to have breached its duty if it doesn't disclose that its fee is higher than the total fee normally charged for similar services. So the client might be able to get it elsewhere at a different fee, at a lower fee. But they've been fairly flexible, I think, overall in terms of percentage guidelines. I think traditional money management, I don't know, it seems like around 3% seems to be a gating factor for reasonable and not reasonable, and when certain kinds of disclosure are required. Now, in terms of termination fees, the Advisors Act doesn't really prohibit termination fees per se, but I think the SEC has sort of interpreted that to mean that that an advisor, you know, certainly could not enforce a contract that, you know, that limits a client's right of termination and somehow bootstrap itself into a higher fee. And they do require that at termination, the client has to get a pro rata refund of the advance fees and the prepaid fees, except for those that are considered administrative or repayment of expenses. So there's some things going on there. Now, performance fees. Performance fees are very popular. I mean, you see them out there in the institutional world. You clearly see them in the hedge fund, alternative fund world. And every now and then we're getting on the ERISA side, we're getting advisors that are coming with discretionary management. And they're saying, well, if I really, really generate some returns, am I entitled to have a performance fee, even in a directly in a retirement plan setting, as compared to being a manager, of an ERISA fund, that's in the alternative space, with a hedge fund or something. So they're very popular. They're here to stay. A hedge fund advisor might get advisory fee, 70 bits, 100 bits, whatever, and then 20% of the profits. And these are, there's also performance fees that are known as fulcrum fees, where the advisor kind of adjusts its base up or down depending on the performance of the fund compared to an index. Now, there's a prohibition against the deduction of performance fees, and it's in the Advisors Act, and that says that an advisor can't receive compensation on the basis of a share of capital gains or capital appreciation of the funds. So it's important to remember this applies only to fees that are based on a share of capital gains or capital appreciation, not to the fees based on other measures of performance like dividends, for example. So obviously the purpose here is pretty clear. They didn't want to give anyone an incentive to become a riverboat gambler with client money, shooting for the big return and the big fee. And I think that's been generally accepted for a while, for a long time. But not all fee arrangements that are based in whole or in part on capital gains or appreciation are necessarily prohibited. You can have asset-based fees, for example, fees that vary proportionally with an index. And these are called fulcrum fee arrangements, performance fee arrangements with wealthy clients that are of a certain sophistication and disclosure. So these are all set forth in Section 205 of the Advisors Act, and a little bit under the rules for Section 205. Let me see if I can talk about them here with you quickly. You can have a direct incentive fee, and this is where an advisor gets compensation based on profits, which are capital gains or capital appreciation. That's okay. And a certain example would be one that provides for an asset fee of 100 bips and then 15% of any gains in the account. So here, good performance is rewarded, but there's no penalty for poor performance. Now, the SEC does not like contingent fee arrangements. In other words, fees where the advisory fee is received, it's contingent on the investment. It's contingent on the investment performance of an account. The SEC doesn't like contingent fees because the client's obligation to pay the fee depends on whether or not the client's account achieves a specified level of gains or not, and they're generally not too happy with those. And there's a separate set of rules for mutual funds. And then there are also some exceptions, for asset-based fees. The advisors are allowed to charge an asset-based fee, and obviously capital appreciation is part of that, and it looks like they'd be prohibited, but percentage of trading, but section, I think it's 205B1 of the Advisors Act permits asset-based arrangements, says that it's okay. And there's also an exception for fulcrum fees. Now, governmental plans and collective trust funds and certain accounts are not eligible to rely on this particular exception for fulcrum fees, but they might fit under the other exceptions under Rule 205-3. And again, in a fulcrum fee, these are incentive fee arrangements. The base fee goes up or down depending on how well the account does relative to the market. And the Advisors Act says that this fulcrum fee has to be structured so the compensation is based on the asset value of the company or the fund under management averaged over a specified period, increasing and decreasing proportionately with the investment performance of the company over a specified period in relation to the investment record of an appropriate index. So these fees, can be structured And an advisor using a fulcrum fee has to, select an appropriate index, make sure that the performance of assets and the performance of the index are measured over a specified time, and that the investment performance must be computed in accordance with, certain SEC rules, regulations. So they're definitely very doable. An appropriate index, there's a lot of flexibility actually there in terms of selecting an index. The SEC has provided guidance going back to 1972 as to how it's appropriate. Factors like the volatility, diversification of the holdings, the kind of securities owned, the objectives of the fund, those are all things that would be relevant. I think in terms, having the certainty over the period over which performance is measured, the key there is that a period should be selected that provides a reasonable basis for judging the advisor's performance. Either the Advisors Act itself doesn't specify a particular length of time, but the SEC has said that the advisor has a fiduciary obligation to use a time period that's sufficiently long to provide a reasonable basis for indicating performance. At least 1 year interval, I think. That way you're not basing it upon a random short-term fluctuation. And finally, as I mentioned before, under Rule 205-3, there's an exception, another exception for performance fees that fits in. It's kind of an exception for wealthy clients, basically. And it's a rule that was first set out back in, I think, 1985. It's been amended a couple of times. And it basically says that, the client has to satisfy certain eligibility requirements and has a certain level of sophistication, and it's going to be adjusted. They'll be adjusted. This qualified client standard will be adjusted over time for inflation, and there's some rules about carving out net worth of your home, primary residence, for individual accounts, things like that. So I think right now it's an advisor can charge a fee to a client who at the time you enter into the contract with the advisor, the client either has $1 million in assets under management with that advisor, or a net worth of at least $2 million. And those are higher thresholds than back in the 80s when it was first adopted. Now, ERISA takes a turn in terms of performance fees. I think it's a slightly higher standard, a little trickier water to navigate, but they're clearly allowable. I mean, there's official DOL guidance on it. So I think the thing here is that, they're very common, and we see a lot of funds that compensate managers with incentive arrangements and benefits the manager. And if they're working right, it's generating the fund as well because some good returns are being generated. There's a series of DOL advisory opinions back in the late 80s and then one in 1999 where the DOL said that, under certain circumstances, very fact-specific cases, that ERISA didn't prohibit a plan from entering into incentive comp arrangements. And these have been issued in the context of securities trading and commodity trading. And the opinions talk about, what fees would be considered reasonable as well, because that's, they don't talk about what's considered reasonable because that's an inherently factual question based on those facts. But taken as a whole, when you look at these DOL rulings, we kind of know we can kind of draw up the following common criteria or factors for ERISA performance fees. We want to know that your investing plan has assets of at least $50 million and that no more than 10% of its assets will be managed by the manager. Now, that's not a hard rule. That rule just applies to the facts at hand in the advisory opinion. We've been taking this a benchmark. We've seen smaller investing plans, less than $50 million, that we're aware of. So I think there is a little flexibility to work around these when you take them in context, but the guidance, as far as we know it, talks about $50 million. The advisory opinions like to see investments that are generally in securities where market quotations are readily available, or if they're not readily available, the assets will be valued on specific rules by a party that's independent and is reliable. So valuation is really important. You want to see situations where the investment manager is not a market maker for any of the assets, in that account for which the performance comp is being generated. You want to see compliance with SEC Rule 205-3. That's the wealthy investor rule we talked about a few moments ago. Clearly, you want to see compensation that's based on net appreciation that recognizes both realized and unrealized gains and losses during a very well-defined valuation period. In other words, you have a really tight definition of when the assets are valued, how they're valued, who's valuing them, is that person independent and reliable, if you will. And compensation must be reasonable. And we all know that's a subjective question, but probably benchmarking against other arrangements in the marketplace would give us some sense of that. And I think one of the most important things is that the plan itself that's either investing in the hedge fund or directly retaining a manager for performance comp, that the plan fiduciary has authorized the incentive compensation, hopefully through some good disclosure or, with disclosure of good documents or some direct disclosures and representations and warranties. And you want to know that the plan fiduciary, they have some experience, they're sophisticated, they're capable of understanding the compensation formula and the risks that come with it. Those are all fact questions, but good reps and warranties in your agreements and good performance comp structures will help get you there. So as I said before, so these are common denominators from the advisory opinions. They're based on the facts at hand. Doesn't necessarily limit the availability of performance comp to other situations that we have now. We just have to be careful as to how we analyze them because they're all going to be very fact specific. And I think that, again, the important things seem to be that assets are capable of good valuation, or if they don't have a readily ascertainable value, that there's some independence involved in terms of entering into the engagement and how they were valued, and that we have relatively sophisticated, knowledgeable plans, independent fiduciaries making the decision to come into the compensation arrangement. So those are my thoughts for today. I hope this has been helpful to you. If you have any questions, you can email them to me. We touched on a few of the things that are core to advisory agreements in addition to the ERISA discussions that we have from time to time. We talked about the nature of compensation, these agreements from an SEC point of view, and the current treatment of performance comp, both by the SEC and the Department of Labor, to performance comp or incentive compensation considerations. I hope this has been helpful for you. Thank you very much for attending, and we will look forward to seeing you at our next webinar.